Well, Amazon filed a response to Parler's request for a temporary restraining order, and it's a pretty good response. Viva Frei, Montreal litigator turned YouTuber, and here is a follow-up in my vlog from yesterday where I broke down Parler's lawsuit against Amazon Web Services. Amazon filed a response to Parler's request for a temporary restraining order, and the response is pretty good. Now, this goes back to something I have said multiple times in previous vlogs. Litigation is not a one-way street. Litigation is a two-way street where everyone takes turns punching, and right now it is Amazon's turn to punch back at Parler, and they punch pretty good. They make a few good shots. For those of you who may not know, Parler is sort of like a Twitter-type platform where people can go and make what they call parlays. It's basically Twitter, but on Parler. Parler operated by way of an app that was available on Google Play and iTunes App Store, and the other day, both Google and Apple pulled the app from their stores because of what happened on Capitol Hill and certain parlays or tweets on Parler that they felt breached their terms of service, so they pulled the app from their store. Not only did Google and Apple pull the app from the store pretty much simultaneously, but also simultaneously, Amazon Web Services pulled their web services to Parler, thus effectively wiping it off the face of the internet overnight. Parler filed a lawsuit against Amazon Web Services alleging breach of contract, violation of antitrust laws, seeking a temporary restraining order, and other damages. I broke down that lawsuit in my last vlog, so if you haven't watched that, give that a watch, then give this vlog a watch. Parler filed suit, and Amazon just filed a response to that suit, and the response makes some pretty darn good points, but it has some pretty big weaknesses in it, in my humble opinion, so let's get into breaking it down. Defendant Amazon Web Services Inc.'s opposition to Parler LLC's motion for temporary restraining order. Just an important distinction to make here before we get started. This is not a defense to the lawsuit on the merits. This is merely a response to Parler's petition for a temporary restraining order, so the grounds of contestation are limited to the temporary restraining order itself. If the lawsuit moves forward, there will be discoveries, there will be a loftier defense on the merits. Right now, we are dealing only with the issue of whether or not the court should issue a temporary restraining order. In its introduction, Parler got to frame the debate the way they wanted to. In its response, Amazon gets to frame the debate they want to. Introduction. This case is not about suppressing speech or stifling viewpoints. It is not about conspiracy to restrain trade. Instead, this case is about Parler's demonstrated unwillingness and inability to remove from the servers of Amazon Web Services content that threatens the public safety, such as by inciting and planning the rape, torture, and assassination of named public officials and private citizens. Right off the bat, Amazon is using quite dramatic and shocking terminology so as to frame the debate in such a manner that no reasonable person could contest what Amazon chose to do in this case. There is no legal basis in AWS's customer agreements or otherwise to compel AWS to host content of this nature. AWS notified Parler repeatedly that its content violated the parties' agreement, requested removal, and reviewed Parler's plan to address the problem, only to determine that Parler was both unwilling and unable to do so. AWS suspended Parler's account as a last resort to prevent further access to such content, including plans for violence to disrupt the impending presidential transition. Despite Parler's rhetoric, its lawsuit is no more than a meritless claim for breach of contract. But the facts are unequivocal. If there is any breach, it is Parler's demonstrated failure and inability to identify and remove such content. AWS was well within its rights to suspend Parler immediately for those failures. Parler also cannot hold AWS liable in tort for enforcing the agreement's express terms. And there is no antitrust claim where, as here, Parler cannot plausibly plead an agreement to cause it harm, and the complaint of conduct is undeniably compatible with a legitimate purpose. Now, there is a fine line between framing the debate the way you want to and creating a straw man argument, and I think Amazon goes a little bit towards the straw man argument side of things with this final paragraph of the introduction. Compelling AWS to host content that plans, encourages, or incites violence would be unprecedented. Now, I say that this is something of a straw man argument because I don't think anyone is really going to believe, let alone a judge, that what Parler is asking is that AWS host illegal content. On the contrary, I am relatively certain that Parler is going to respond that they are not asking the court to order AWS to allow them to host illegal content, rather that they are ordering AWS to respect its contract with Parler, and that Parler will continue to respect the terms of that contract. That Parler has in place a system that allows it to identify and remove illegal content from the website, and if AWS finds any objectionable content on the website, that they so notify Parler so that Parler can act accordingly, as opposed to just pulling the plug on Parler overnight and literally killing its business. Amazon then presents its side of the factual background, which it explains as follows. Parler conducts the, quote, absolute minimum, end quote, of content moderation. Parler operates a social media service that has gained favor as an alternative to Facebook and Twitter. Parler prides itself on its hands-on hands-off approach to moderating user content. Parler's homepage tells users to, quote, speak freely and express yourself openly without fear of being deplatformed for your views, end quote. In interviews, Parler CEO has stated he, quote, doesn't think it's Parler's obligation to, end quote, monitor the full range of its users' content, and promoted the service's laissez-faire philosophy on content moderation. Quote, if you can say it on the street of New York, you can say it on Parler, end quote. Amazon then alleges that on June 12, 2018, Parler entered into an agreement with Amazon, and the relevant terms or essence of the agreement is as follows. The agreement requires that Parler, quote, ensure that your content and your and end users' use of your content or the service offerings will not violate any of the policies or any applicable law, end quote, and makes clear that Parler is, quote, solely responsible for the development, content, operation, maintenance, and use of the material on its service. The agreement also requires Parler to, quote, immediately suspend access, end quote, to content that it learns violates its obligations under the agreement. Parler further agreed to comply with AWS's acceptable use policy. The AUP in turn makes clear Parler's agreement not to use AWS to host certain content, including content that, quote, violates the rights of others or that may be harmful to others, end quote. Amazon's response then goes on to allege that in November 2020, it learned of content on Parler that violated its terms of use by inciting violence or threatening people, and it contacted Parler to learn what it was doing to moderate that type of content. It then goes on to allege that over the next several weeks, they pulled up something like 100 other examples of threatening or insightful content and brought it to Parler's attention, and I'll give you a screen grab of some of those messages so that you can read them for yourself. Amazon's response then goes on to describe the riots on Capitol Hill that occurred on January 6th and the messages that appeared on Parler to explain why on January 9th, Apple, Google, and Amazon pulled the plug on Parler. On January 9, 2021, Apple and Google terminated Parler's accounts. The same day, AWS notified Parler it would suspend its account effective 11:59 p.m. January 10. AWS explained it, quote, remains troubled by the repeated violation of our terms of service, end quote, noting it had, quote, reported 98 examples to Parler of posts that clearly encourage and incite violence, end quote. AWS also reported the, quote, steady increase in this violent content, end quote, making, quote, clear that Parler does not have an effective process to comply with the AWS terms of service, end quote. The email also notes Parler, quote, removes some violent content when contacted by us or others, but not always with urgency, end quote. And Parler's proposed moderation plans, quote, will not work in light of the rapidly growing number of violent posts, end quote. The letter confirms that AWS will, quote, ensure that all of your data is preserved for you to migrate to your own servers and will work with you as best we can to help your migration, end quote. Citing the 100 some odd examples that Amazon refers to in the pleadings, they basically say Parler does respond when it's brought to its attention, but it doesn't have a system in place that ensures that it respects the agreement between the parties. Thus, it is Parler's breach of the agreement, not ours, so Parler cannot sue us. We'll get there. But first, Amazon makes this point which might confuse you, but there is a strategic reason for which they are making it. That evening, Parler's CEO posted that, quote, we should be operational within less than, 12 hours of downtime after Amazon abruptly pulls our access, end quote. He also posted that Parler had, quote, prepared for events like this by never relying on Amazon's proprietary infrastructure and building bare metal products, end quote. Parler filed its complaint and motion for temporary restraining order January 11. Parler alleges no facts that could possibly support its claim for breach of contract, tortious interference with prospective economic advantage, or violations of the Sherman Act. Why is Amazon picking on these two posts of Parler's CEO? It's not only to make fun of the typos in them, it is to show that Parler was saying that they had the means to minimize their damages, and apparently they didn't, so that Parler, if it suffers any excess damages, does so only by its own negligence. That is going to be the argument. I'm not sure that it's going to hold water, because I am fairly certain that Amazon knows by pulling the plug overnight with minimal warning, if any warning whatsoever, they know they are causing damages to Parler's business. Now let's get into the arguments against the issuance of the temporary restraining order. A temporary restraining order is, quote, an extraordinary and drastic remedy, end quote. The standard for issuing a temporary restraining order is, quote, substantially identical, end quote, to the standard for issuing a preliminary injunction. The plaintiff must establish 1. It is likely to succeed on the merits. 2. It is likely to suffer irreparable harm in the absence of preliminary relief. 3. The balance of equities tips in its favor. And 4. An injunction is in the public interest. We have discussed these criteria in previous vlogs where we discussed injunctions, and the funny thing is, in reading Parler's lawsuit, I was asking myself if under American law the drafting of Parler's lawsuit was not somewhat deficient in that they did not make specific allegations of the criteria that need to be proven in order to get a temporary restraining order. In its lawsuit against Amazon, Parler did not make specific allegations about irreparable harm, balance of inconvenience, inconvenience, color of right, and when I sent my video to my friend and other YouTube lawyer Nate Brody for him to have a look at before I published it, I did ask him if this was not going to be a deficiency in the lawsuit itself. I'm curious if they are going to have problems in that they didn't make allegations about balance of inconvenience, color of right, irreparable harm. I don't know if those are formally required under US law to succeed on an injunction. And surprise, surprise, lawyers are going to do their job, so Amazon's lawyers are going to argue that Parler's lawsuit is insufficiently drafted to obtain the temporary restraining order, but first they're going to address the question of breach of contract. AWS did not breach the agreement. To establish a breach of contract, a plaintiff must identify the, quote, specific term of the contract, end quote, the defendant allegedly breached. Parler claims AWS breached the agreement by failing to provide 30 days notice of termination. To be clear, AWS suspended and did not terminate the account. But it was Parler who breached the agreement by hosting content advocating violence and failing to timely take that content down. These are Amazon's arguments, and I happen to think that these are particularly weak arguments for the following reason. First off, I don't think there are going to be many judges who are going to deem that suspension to be a suspension and not in fact a termination. Twitter may use Orwellian and nonsensical terms like a permanent suspension as opposed to a termination, but a judge is going to be able to identify a termination when a judge sees a termination. And what Amazon did was undoubtedly a termination, not a suspension. The second argument, that it was not Amazon but Parler who breached the agreement in their failure to take down offensive content in a timely manner, also is going to fail, I think, because by Amazon's own admission, Parler did in fact take down the content in a pretty timely manner. I don't know the specific terms of the agreement between the parties, but if there is a delay to cure default, that is the delay to cure the default, not Amazon arbitrarily saying you didn't do it fast enough in our opinion this time. So although they are making the best arguments they can with the file as it stands, I do think these two arguments are pretty weak and ought to fail in front of a judge. But I may be wrong, I've been wrong in the past, and I'll be wrong again in the future. Let's move on with the lawsuit. Parler's complaint is replete with insinuations that AWS had equal grounds to suspend Twitter's account and thus discriminated against Parler. For example, Parler cites the hashtag, and you can read it, which briefly trended on Twitter. Briefly, as in a hashtag encouraging violence against a political individual, was taken down in a timely manner, much in the same way Parler responded to its complaints from Amazon. But this is the good point that Amazon makes, although I'm not sure how far it's going to go. But AWS does not host Twitter's feed, so of course it could not have suspended access to Twitter's content. Twitter has since independently blocked that hashtag. Now, this is a good point because there are two different agreements between Amazon and Parler on the one hand and Amazon and Twitter on the other, and we don't know what rights and recourses Amazon can have via Twitter as relates to any violent or insightful conduct. But Parler's point here is that while Amazon decides to continue to do business with Twitter despite identical conduct on Twitter's website, it chooses to exploit that conduct on Parler's website to cancel its contract with Parler to the benefit of Twitter. That despite its own admission that Twitter took down the hashtag in a timely manner, but when Parler takes down the offensive conduct in a timely manner, it decides nonetheless to cancel its agreement with Parler. It decides to cancel its agreement with Parler and cites Parler as being the one who breached that agreement and not Amazon itself. It's a valid argument to make in front of a judge, and I always say that whenever you go in front of a judge, it's pretty much always a crapshoot, notwithstanding how strong you think your argument is, so Amazon may very well succeed. I am just not thoroughly convinced by their argument. I am not convinced by their argument because Amazon is basically holding Parler to an impossible standard to meet. Amazon cites the 100 some odd parlays or tweets on Parler to justify terminating its agreement with Parler. Amazon knows darn well the volume of parlays on Parler. It knows darn well that at any given point in time, it can easily find 1, 2, 100, even more violent parlays on Parler. It is the nature of the internet. It is like whack-a-mole. You cannot prevent people from posting them. You can only respond once they are posted. It's the same on YouTube. It's the same on Twitter. You can't prevent something from starting to trend, but when you notice it's trending, you can end that trend. In the same way that once Amazon notified Parler of the offensive content, Parler did in fact respond to it in a timely manner. But Amazon is creating the impossible standard whereby it can effectively, unilaterally, at any point in time decide to shut down Parler because it can go and find a few offensive tweets on the website. And while deciding to cancel its agreement with Parler for this conduct, it nonetheless maintains its contractual relations with Twitter despite the same conduct. It may not be enough to prove antitrust law violations, but it certainly is enough to potentially prove abuse of right, even assuming Amazon had the right to do it in the first place. We will see where it goes. I happen to think that Parler's strongest argument is in fact on the breach of contract argument and not necessarily on the Sherman Act antitrust violations or the tortious interference, but Amazon goes on to refute the tortious interference argument as well. First and most important, Parler bases its interference claim on its allegations that Amazon, quote, terminated Parler's agreement. However, where the defendant's alleged interference is the exercise of a contractual right, a plaintiff has, quote, no reasonable expectancy and cannot assert an interference claim. Because the agreement permitted Amazon to suspend Parler, Parler cannot assert a tortious interference claim based on the suspension. That entire argument is based on the rather large assumption that Amazon did in fact have the contractual right to do what it did. If it in fact did not have the contractual right to do what it did, well then it seems that Parler might have a claim for tortious interference. To be determined by the judge, but now let's move into their argument against the allegations of violations of the Sherman Act. AWS did not violate the Sherman Act. Plaintiff's complaint fails to plead the most basic elements of a Section 1 claim. Parler's antitrust allegations fail also because they do not even plead the basic requirements of a Sherman Act claim, such as how competition is harmed. This is especially important where, as here, Parler freely admits that it has access to numerous potential web hosting service providers, not claimed to be involved in or restrained by the alleged conspiracy with whom Parler can freely contract. Those alternatives alone preclude Parler from stating a plausible claim for relief. Now, admittedly, I am merely a Quebec attorney with no specific antitrust expertise talking at the world from my car, but I am not convinced by this argument. I am not convinced that because there might be some form of an alternative that necessarily precludes someone from having rights and recourses under the Sherman Act. I am not convinced that a claim under the Sherman Act requires the total absence of any alternative, but rather only the abuse of a monopoly. Indeed, even in establishing something as a monopoly, it does not require 100% market share. I believe it requires something like 80 to 85% market share, which means that there are other alternatives, but means that you're not precluded from filing a claim under the Sherman Act. To be determined, but did Parler allege enough to get a temporary restraining order? As far as the balance of the equities goes, I think Amazon raises another strawman argument. First, compelling AWS to host Parler content would threaten the safety of individuals. This risk is not speculative. That is a strawman argument. Nobody is asking the court to compel Amazon to host Parler content that threatens individuals. They're just asking the court to order Amazon to respect its contract and allow Parler to moderate that content. Second, any injunction would impair AWS's ability to take swift action against customers who misuse its service to promote violence. Also a strawman argument, no it wouldn't. It would only compel Amazon to respect its agreement between the parties. In order to obtain a temporary restraining order, typically the damages that the plaintiff stands to suffer cannot be compensated monetarily, and Amazon argues that any damages Parler does in fact sustain can be compensated monetarily, therefore a TRO should not be issued. And finally, they take one last jab at Parler's CEO and bring back his own words to haunt him. Finally, Parler's allegations of harm contradict its own public statements. Parler's CEO has assured users that Parler, quote, prepared for events like the termination by never relying on Amazon's sick proprietary infrastructure, end quote, that the site will be fully operational, quote, with less than sick 12 hours of downtime after termination, and that Parler has many companies competing for its hosting business. And with respect to the criteria of irreparable harm, Amazon alleges as follows. Parler has failed to show it will suffer irreparable harm absent an injunction. A TRO is also not warranted because Parler has not shown irreparable harm is likely. Irreparable harm is, quote, harm which cannot be redressed by a legal or an equitable remedy following trial. Monetary harm is not, quote, irreparable, end quote, injury. Parler has not identified irreparable harm. AWS has promised to preserve Parler's data and help Parler migrate its services elsewhere. Parler's CEO has acknowledged that the service never has relied on AWS exclusively. He also told Parler users that the service may be operational within 12 hours of AWS's suspension of Parler's account. A temporary service interruption is not irreparable harm, and any alleged harm would be compensable by damages. And this is just sort of a he said, she said type argument. Parler says it will suffer irreparable harm. They have made certain allegations to evidence that claim. Amazon says it won't. They have made certain allegations to refute that claim. I happen to think it is relatively obvious that Parler will in fact suffer some form of irreparable harm in the absence of a TRO, but we will see. And we will see where this goes because they apparently have not yet had the hearing. These hearings are heard on an expedited, urgent basis, obviously given the nature of the lawsuit, so we will see how a judge adjudicates on all of this, but something tells me this will be the saga of 2021. So that is Amazon's response. That is the other side of the two-way street. Let me know what you think. Let me know where you think this is going to go. And as soon as there is a judgment, I will do a follow-up vlog on that judgment. And with that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
Feed me all night long.
If you want to support the channel, all of these support links are in the pinned comment. If you want to follow Robert Barnes and we have a page on Locals. It is called vivabarneslaw.locals.com. I am also on Rumble, but more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.